Welcome to the latest episode of Call to the Bar, International Law Over Drinks. I'm your hostess with the mostest, Dr. Tamsin Phillipa Paige, Associate Professor at Deakin Law School. Today we are discussing the legal status of assassinations in warfare and statecraft with my delightful co-host, Professor Douglas Guilfoyle, Associate Dean Research at UNSW Canberra, Dr. Alonso Gurmendi Dunkelberg, LSE Fellow in Human Rights at the London School of Economics and Political Science, and soon to be Dr. Emma Lush, PhD scholar at Adelaide Law School, which is a place close to my heart because I did my PhD there and had many a coffee with one of Emma's supervisors, Stacey Henderson, about various issues we had with supervisors. It's a fine PhD bonding tradition. I recommend you all engage in it. Before we begin, I remind everyone that in these informal conversations, we are, as always, speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. And before we get down to business, our traditional first question: Emma, Alonso, Douglas, what's your drink?
I wonder if I should begin, given that I was the first one mentioned, but I thought I'm drinking my homegrown chamomile tea with copious amounts of honey in it, given that my voice is a little bit sore. But I really do like growing my own teas, and so I thought, what a nice place to be able to, spruik that and throw it in there as a little bit of a humble brag.
What's your favorite homegrown tea? I've got to know.
Oh, definitely free mint. Yeah.
Mm-hmm.
Yeah. The
Oh,
great thing about mint is you can't kill it, and so it's
no,
always coming back.
it just colonizes the entire vegetable garden.
Really does.
Well, I was second to mention, so I will say I have a little bit of I've earned a little bit of leeway with the Call to the Bar team, so I'm being extremely boring today because it is in the morning, and so I just grabbed a bottle of water from one of the LSE events, so don't rat on me. My
Pretty
throat is
certain you
also
just
sore,
ratted on yourself.
but they don't, no, it's a sociology school. They don't listen to the. No, my throat is also sick, so I'm just gonna go with water. I'll have something more entertaining the next time because now I know where they sell Inca Cola in London. Inca Cola is like the Peruvian, national soda drink that was sadly bought by Coca-Cola. And so now I know where I can buy it easily. I don't need to go all the way to Elephant and Castle anymore, so I can do this. So next time it'll be more interesting.
Excellent. Although I'm sure in my career as a graduate student and junior academic in the UK, I stole much more bottles from various functions in my time. But I'm presently drinking from Emma's region of the world, a Barossa Chardonnay, which is how I'm coping with the rage induced by both world events and my attempt to move to a lower carb, lower sugar diet. Chardonnay from the Barossa obviously being notoriously free of both carbohydrates and sugar, and therefore not counting as a cheat at all. But I think we also mention not only is Adelaide University a fabulous place to do, or Adelaide's a fabulous place in general, but also it created an enormous sequence of Australian law of the sea scholars who went on to international acclaim. So you had, Daniel O'Connell and Ivan Shearer and James Crawford all out of that illustrious stable.
And then you had Tamsin Page, who's not yet illustrious, but did share an office with Ivan Shearer when I was in my PhD.
Ivan Shearer, blessed of memory and late of this parish, just one of the loveliest people in international law.
Hard agree. As for my beverage, I have a Sicilian orange hot chocolate from Grounded Pleasures. I wanted their French mint, but it turns out I'm out of it, so I'm a little hurt by that. But it's a wee bit nippy as a turn of weather here in Canberra, so it felt like perfect hot chocolate weather. So that's my beverage. And now, Emma, you've not been on the pod before, and we usually start by asking you guests, how did you get into international law? And what career path brought you to your present job?
It's, I kind of fell into international law. When I graduated from my undergraduate degree in 2016, I went and I volunteered with the Asylum Seeker Resource Centre for a little while, and then went and practiced. Now, I practice as an employment solicitor doing sort of unfair dismissals and general protections claims for employees. And then was doing my master's by coursework at the University of Melbourne and took a subject with John Tobin, just on sort of very basic, broad international human rights law, and just loved it. I really loved it. And so the rest of my coursework was entirely international law based subjects. And from that point, I went, I don't think I really want to be in practice anymore. I think I'd like to sort of pursue this sort of more cerebral thinking about the law path. And so called up Peter Burden and said, hey, I'd really like to do a PhD in international law and give it sort of a political theory bent. And so the rest is sort of history. And so here we are, nearly finished my PhD in international law, and going on to bigger and better things in academia, hopefully.
We can only hope, and I'm sure that that's exactly what will happen. I have to ask, hearing your timeline, you didn't have the misfortune of PhD me having to teach you international law at Adelaide, did you?
I didn't have the pleasure, Tamsin. I had Rebecca and Dale.
Rebecca and Dale were running it, but I was I was doing a lot of marking and seminar teaching for them, which is why I'm like, I have to check because I did.
I think it was 2014 or 2015.
If it was 2015, you couldn't have had me. If it was 2014, you might have. That was why I had to ask.
There you go. I think it was 2015.
Classic call to the bar bingo. We have another refugee from practice.
Yeah, it's the way.
Recovering lawyer, as I like to say.
I also started with labor law. My first job was labor law as an intern. I remember thinking, how can you have a body of law that is so interesting to think about and so boring to practice?
See, I will just state for all of the connections, my partner is a labor lawyer who, after returning to practice from completing her PhD, went, fuck, this is boring, and has moved into policy. So there we go. Full circle of connections right there. Now, let's move on to our main event, which is Assassinations, which, to quote The Princess Bride, has a long and glorious tradition. Beyond all the Cold War attempts to assassinate Fidel Castro and other leaders that the CIA and KGB didn't like with varying degrees of success, more recently we are seeing a return to the use of assassination quite openly by states. From the numerous Russian assassinations, and Wikipedia lists 82 since the year 2000, to the US assassinations, with Wikipedia listing around 1,065, but the number's probably higher. They kind of get vague on some of the numbers in the places. Most of them via drone strike and mostly in the Middle East. And Israeli assassinations that, frankly, that Wikipedia list is massive and quite concerning. Mostly Palestinians, a fair number of Syrian, Lebanese, and Iranian nationals as well. It would seem that in the last 25 years, assassination has become the new black in statecraft for certain states. So what's going on here, noting that we're going to get to the legality question later?
I can take it. Okay, I've been thinking a lot about not just assassination as a prism for war, but the way that war is being fought today. Because if we look at the history of these assassinations, usually assassination was something that happened outside of you wanted to kill someone when there wasn't a war. When rather now you have discourses that would argue that when you try to assassinate someone, you immediately trigger a war, and that makes the assassination legal, right? So the whole first strikes theory of like whenever you launch a war, as soon as an armed attack starts, you trigger an armed conflict, and therefore when the bullet lands, the assassination. And so I've been thinking a lot about what this means. And there was this piece of news that came out from the war in Iran, of all places, where it said that Israel had run out of targets in the war. And I thought, like, but wait a minute, how can you run out of targets? Like, okay, the way a war works is you have two armies going after each other, each securing their own objectives. and targets pop up as you pursue your objectives. There's no such finite number of targets that you know in advance. But Israel had that. They had a list of targets that they wanted to hit. And then they just ran out of them. They didn't know what to do because like, okay, now what do we hit? There's no more targets. And so that's when the discussion about hitting, power plants and nuclear power plants and whatever started emerging. And so it looks to me as if like what's going on now in this like new version of war that we are discovering in the drone AI era is that war has become a series of individualized assassinations. So what I see is that war is now about you have a list of people that you want to target, and you get them off a list. That's a war now. Of course, that doesn't mean that that's all the wars that there are, but in a way, the drone era, the targeted killings era, has turned the very phenomenon of war into just a series of assassinations. And that has made it so that we don't really have these scenarios where, like, oh, the US tries to assassinate Fidel Castro outside of a war. Even individual assassinations, even like Soleimani's assassination by the United States in the first Trump administration, was then described as when you shoot the missile, you trigger an armed conflict, and therefore when that bomb explodes, there's already an armed conflict, and therefore it's legal. And so that's what I think is happening. I think war is transitioning to something else.
I have a quick question on some details here before we continue this discussion on the nature of what's going on here. Does the Israel running out of targets thing then correlate with them deciding to invade Lebanon?
I think those are two separate things.
I wasn't certain if there was a correlation in timing of they ran out of targets, so they found targets elsewhere, because that just would have been horrific. And I was curious if there was any correlation because I had not heard the run out of targets thing.
I mean, in Lebanon, there's another thing, right? In Lebanon, the thing is that the target becomes an entire village, which is terrifying. Like we've gone from a military target is a civilian object can be a military target if it's being used for military purpose at a specific time. And then we went from that to, okay, if you have a stockpile of weapons in the basement of a building, the parking lot of a building, it's not that parking lot that's the target, it's the entire building. And now we've gone to, no, actually, it's the entire village. It's quite frankly very scary to think about how we are destroying any semblance of international humanitarian law.
I'd agree with Alonso's conclusion, but I think the destruction of entire villages is sort of in some ways a separate point from our thread on assassinations, right? I think that's a distinct phenomena about Israel creating a buffer space or a greater Israel. So I think that really goes to actually the resurgence of acquisition of territory by conquest. Now, we can all say it's illegal, but it's quite clear that a couple of states are attempting to move in that direction. But,
yeah, sorry, that was me derailing things, and I'm sorry about that.
Well, it's the shared privilege to derail the conversation. But just to pick up on a couple of threads from Alonso, I think in part, and this was something Alonso said, but I'd just like to draw it out a bit further, this has been technologically driven, right? And the promise of drone warfare was one, that you could be very precise, and two, that it could be relatively bloodless in terms of losses of your own military. Emma has a cat. Sorry, distracted by pets. And what we see there is this greater emphasis on the idea of decapitation strikes. If we can just remove the leadership, then the war will be over. And with the running out of targets, I mean, Israel had two AI systems that were helping generate targets, or possibly just generating targets with human rubber stamping. Lavender, and more appallingly named Where's Daddy, which was a program that identified allegedly Hezbollah-linked people and where they lived, so they could be assassinated at night, usually with their families, right? Because then you were certain where they were. So the question there was around collateral damage. But one of the things that arose in some of the investigative journalism reporting around that was this idea that, Israel was running out of things to bomb. So you relaxed the AI parameters to widen the target list. But at a certain point, the profile of someone who is embedded in certain communication networks, moves quickly in response to rapid military events, blah, 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 is as likely to be an ambulance worker or a police officer as a Hamas militant. So they had to rein the parameters back again.
Or possibly a food delivery person.
Well, indeed. But the other thing that I think that the sort of an interesting point made by the strategist David Kilcullen as regards Afghanistan was that he took the view that at a strategic level, there were strategic consequences of the tactical appeal of targeting leaders with drones. His point being that in the campaign in Afghanistan, in attempting decapitation strikes based on precise intelligence with precise technologies, you took out all the leaders who were old, infirm, or just there because of status, not because of professionalism or talent. And you actually, essentially, in a Darwinian series of cycles, eliminated incompetence from the Taliban leadership through assassination strikes and improved the quality of leadership that you were encountering on the other side. Because what you were left with those who were cunning enough, strategically and tactically adroit enough to avoid drone-based decapitation strikes. So what was meant to lead to bloodless warfare, where you'd eliminate the leadership, everyone else would surrender, and there'd be no need for boots on the ground, actually produced better theatre-level leadership amongst the adversary, because you'd eliminated all the dead wood above them.
And that is horrific. And that, Emma, do you have anything you kind of want to add to this point and all of that? Yeah, please chime in.
Yeah, of course. So I think something that I'd like to, I've been thinking a lot about the way that this question is framed. And something that strikes me is that perhaps this is less about sort of, I think the way that you framed it in your question was like the return to the use of assassination, and more about the development of assassination as something covert and almost like illegal sounding. So when you talk about assassination in sort of like a lay person's terms, you get this sort of very covert, espionage-y kind of idea that governments do that's tied to spying, to something that has become almost like a legal tool of statecraft. And I don't think it would be too far of a stretch to say that it has become, at least for those states who practice it now, and it's, the US and Israel, but obviously there's other states as well, in this post 9/11 world, that's something to almost celebrate. It's quite a stark difference from the decapitation of, say, the South Vietnamese government in the early 60s, where the US administration sort of publicly denied involvement, to today in 2026, where Trump is openly posting on, I think it's called Truth Social, almost in real time, to celebrate the killing of Khamenei. And a point that is really made quite excellently by, I think it's Marcus Gunnerflew, if I'm so sorry if I'm mispronouncing that, in his book Targeted Killing, which is that so-called discriminate state killings that are sanctioned by states, whether we call that assassination or targeted killing, are certainly not new, and in fact are not just used, but are deeply interwoven into the statecraft of powerful states like the US and Israel. And I know that we'll get to the legal question later, so I don't want to touch on it too much, but I think it's worth reiterating that such killings have been used as sort of an extension of state power for quite some time now, whether in the shadows of the government in the 70s and 80s, to being almost used as like a propaganda tool post 9/11. So I wonder if there isn't a question to interrogate that, rather than its return or its uptake by states, how did we go from assassination being something that it was sort of covert, something being openly celebrated by states that use it in the 21st century? Or even if I was to maybe go a little bit materialist, what is it about this particular historical moment in this post 9/11 world that's led to this sort of open use of targeted killing or assassination? And I think it's something that I'd like to return to, because I think it's quite relevant to the question of legality, is this steady development of the juridification of war. And that's something that we can map throughout the decades as lawyers become increasingly involved in war, but specifically in targeting operations. And if I could give a shout out to Craig Jones's book, The War Lawyers, which is just such an excellent account and insight in the shaping and consequences of the US and Israel's approach to targeted killings in the 21st century in an age of lawfare and the juridification of war, where every aspect of a war has been operationalized and scrutinized by military lawyers, gives these actions sort of like this air of legitimacy and legality. So we have this timeline, this development of this like state-sanctioned killing, where much of the language used around targeted killings is directly related to this weaponized legality. We're neutralizing these, and we've seen it in the last, couple of weeks, these perceived threats is framed not only as a lawful exercise of defensive force, but also necessary to safeguard the national security of these powerful states. Yeah.
So just on that, I think one of the reasons why assassination has now become accepted, if you will, is because of how war has been manipulated. I don't know. I don't know. So Douglas has one of my favorite definitions of law that I've ever read. You once tweeted that like on Twitter, and it just stayed with me. Law is the manipulation of language to advance socially value or things that are perceived as socially valuable. And I just love that definition. It stayed with me for a very long time. And I think that's what's going on now with war. War has become a way to manipulate language, to grab things that used to be seen as negative and shift it into this horrible thing, but that has to be understood and justified. You need to understand that this is war and war is hell, right? So we used to have, like, I'm Peruvian. In Peru, if you said Peru had an armed conflict, meaning Peru had a war, you were generally perceived as a terrorist. Because no, you cannot give a terrorist organization the status of a war belligerent. It doesn't matter if it's a non-international armed conflict or not. You cannot do that because then you're like, let's say, idealizing them or giving them some extra rights. After 9/11, though, that changed. And now terrorism stopped being something that you deal with police forces and FBIs and like SWAT teams and became war, right? And war is hell, and therefore you can just start shooting at the terrorists. And this is why terrorism has become so popular for basically everything. Like in El Salvador, Nayib Bukele says that the gang members are terrorists and therefore they are assigned to the war paradigm. Same thing happened in Mexico. Same thing is happening to Peru. In Peru, we're like shooting down airplanes, like civilian airplanes, because they are drug airplanes. They're transporting drugs and therefore they can be shot down. And I think something similar is happening to assassination, just like armed conflict and was used to sanitize human rights violations in cases of terrorism. Now they're being used to sanitize assassination. War has become a bunch of assassination. And while assassination sounds bad, war sounds like bad but necessary. And it's the power of language at play. We just reframed everyone's brain. It's been a massive operation of rewiring people's brains into thinking, oh, but you need to understand that this is war. You can destroy an entire village because it's war. And people say this openly now on social media. What do you think war is like? And I just think we're going to need so much counter-programming to get people to understand that this is not normal. Because there's an entire generation of human beings that has grown up in the war on terror, in this idea that war justifies everything and war creeps into every aspect of society. There are kids that have been born and have been in forever war. There's not been a single time where they have not been living in a country that is at war with some kind of like amorphous terrorist organization. It's very scary.
Well, and on top of that, in Australia, we've just sort of spent, $200 million in public funds running investigations into alleged Australian war crimes in Afghanistan, managed to arrest two people, one of them Australia's most decorated soldier, Ben Roberts-Smith. And we have billionaire mining oligarchs in this country saying, I literally do not understand why you would prosecute an Australian soldier for things they did in a war. So we have this massive public education opportunity. We've already had it. In fact, we've had, the dry run of the Blanton report. We've had the dry run of unsuccessful defamation proceedings brought by, Ben Robert Smith, in which it was judicially determined that on the balance of probabilities, he was a war criminal. And it was also found on the balance of probabilities that the crimes he'd committed had, disgraced both him and his nationality, which was one of the allegations that he sought to bring against the newspapers. And that has been refuted by, 3 judges of the federal court and appeal denied at the High Court. But we still have people in this country going, well, why would you prosecute soldiers for things done abroad?
And not just billionaires, the Prime Minister who sent him there as well, saying, well, how could you do that? How this is un-Australian to prosecute war criminals, as John Howard basically said. So
yeah, and also to jump on Alonso's point, just generally society at large, looking at the general, I guess, the reactions of people broadly, there's almost this feeling of how dare you prosecute someone, who went to a situation that you can't even comprehend. They did things that were necessary in the sort of in a war, and there's no critical thinking there, but it is very much this sort of programming that Alonso was talking about the way that war is seen, as opposed to when you just isolate it as, illegal sounding covert assassination or whatever it might be.
yeah, and I said, this brings to mind the fact that I spent a good portion of the day preparing for this episode, making a GIF from season 6 of Archer about the difference between extrajudicial killings and assassinations. And this thoroughly springs to mind, how do we deal with the loaded linguistic issues at play here. But moving on from the linguistic and statecraft issues, the question then becomes, what are we legally to make of this behavior? So outside an armed conflict, this would prima facie violate Article 2.4 of the Charter. I have to be reminded occasionally that things other than the UN Charter sometimes have an Article 2.4, so I have to be more precise. But would it meet the armed attack threshold to activate Article 51? Because it may not meet the scale and effects tests of Nicaragua and oil platforms. In an armed conflict situation, what are we to make of this, especially since it isn't clear that all of these targets were military or DPH? And for example, in this one, I'm referring to the incident on 29 January this year, when Israeli special forces disguised themselves as medical personnel and civilians to sneak into a hospital in the West Bank, I think, to kill 3 Palestinian men, one of whom was recovering from wounds sustained in an airstrike. And my source for those facts are the UN OHCHR press release on the incident, which Douglas will put in the show notes. So, yeah, legally, what's going on here? Talk to me, people.
I can start off by saying, Tamsin, you have raised an important point of framing. So, as it's sometimes put, we don't have a law of horses. We have the word horses. We definitely know what a horse is when we see it, but how a horse is regulated might be different according to animal welfare law, traffic law, road use law, whatever. So assassination is a rather than a term of legal art. So we need to break out what are the relevant legal categories. And if you said, if there's not an ongoing armed conflict, we might be dealing with questions under human rights law and potentially use of force law. If there is an armed conflict, we need potentially to distinguish between an international armed conflict between states and a non-international armed conflict. Certainly in the latter category, non-international armed conflicts where the adversary is not a state, there is a question about when people who are not part of a state military are targetable, which goes directly to your last point about the Israeli raid on a particular hospital. So I just want to kind of plant a flag early that we're not dealing with one bundled up category, and we have to sort of pre-categorize the situation to determine the applicable law. But certainly in a conflict between states, if there's already an ongoing conflict, as I understand it, and Emma and Alonso are the subject matter specialists, but you could lawfully target the civilian head of state if they were ultimately controlling and directing military operations. So in, for example, World War II, it would have been perfectly legal for Axis forces to attempt to assassinate Winston Churchill. That would have been fine. He had, in the parlance we usually associate with non-international armed conflicts, a continuous combat function. He was directing military operations throughout. So while we might call that an assassination, really it's just a perfectly ordinary part of the law of targeting. Anyway, with that flag planted, I'll turn it over to the people who really know what they're talking about.
Okay. I agree with everything that Douglas has said. I do think that I remember a journalist once asked me, can we discuss the illegality of these types of assassinations? And I explained the law surrounding these like operations within armed conflict and how nuanced it was, and they were like, yeah, this is too complicated to print. So they were like, okay, next question. I'm not even gonna ask that because I think what they were looking for was that angle of the assassination sounds bad. And therefore, I want you to tell me how the law protects me or us or whoever from assassination. In this case, Khamenei. Sorry, in Spanish it's pronounced differently. So like, I think it's Khamenei in English. And so they were like, can you explain to me why this is illegal? I was like, well, I mean, it depends on whether he had a continuous combat function and whether you can argue there was an armed conflict at the moment of the strike, and then there's first strikes. And then the journalist went like, okay, how about we talk about something else? So I agree that the situation is complicated in terms of like the applicable law. I guess I would touch upon this in two levels. One is the meta level about how the law is weaponized and used, as I was saying before, to enable things that should be frowned upon, like the AI systems that you describe, or the fact of like someone is running out of targets in a war, how war has become this like series of small assassinations. And I think a lot of the law is sort of like breaking down. I remember having a discussion when Soleimani, the Iranian general, was assassinated. I remember having this discussion about whether it was legal or not under lex specialis arguments, like the idea that if there's an armed conflict from the moment you shoot the missile, armed conflict appears, then that's the first strike. And so when the missile lands and kills someone under IHL, it is legal, or it would be legal. That is such a stretch. And then I remember Adil Haq saying, well, wait a minute, it's an act of aggression. And therefore, if it's an act of aggression, it might be legal under IHL, but it would be illegal under human rights law because it's an act of aggression, because of General Comment 36. And it just felt like such a... I mean, I agree with Adil, and I side with him, and I've used his argument ever since to argue like, okay, it might be legal under IHL under this extended idea of like first strikes, but it is definitely contrary to human rights. But it just gets me thinking again into the strategic uses of the law as this way to change reality through language. And all I can think about is how this law is fundamentally broken, and the discussion on assassination reveals it. Because yes, there's different sets of rules that apply to different situations, but what we are seeing now is an attempt by the actors that are using this law to make sure that actually we don't have the situation that Douglas is describing, where there's like different rules for different scenarios. No, everything is covered by this thing called law of war, and you can do anything you want. You can go into a hospital dressed up like a doctor and shoot someone in a bed. And that's not an assassination because it's war. So there's this problem of the lex lata, like how the law actually is, and then how it's been manipulated and abused and misused. And I'm not sure that the law itself, IHL and even ICL, International Criminal Law, has the tools to prevent that. Like, are we ever going to see these Israeli soldiers prosecuted for disguising themselves as doctors and executing someone? Probably not. If it's as difficult as you're saying in Australia to prosecute, I know in Peru it was extremely difficult to prosecute our soldiers. I just don't see what mechanisms this law has to actually regulate itself and prevent its misuse. And that's what frustrates me the most. At some point, I get to the point where I say, this is all broken. It doesn't work. We need to start anew. And we need to go to a place where the general mindset in the imagination of people is there should be no war. War should be completely illegal, and nothing you do in war should be valid. And I just abolish war and let's try to get there more than regulate war. And now Simon Moyne somewhere is very happy.
I was about to say that. How very morning of you, Alonso.
Can I chime in with a couple of clarifications here and questions? Now, first of all, the Israeli situation we're talking about, even if we can call that not an assassination, no, I agree with you that that's a bullshit argument. Wouldn't it still be perfidy and targeting of hors de combat soldiers who therefore are also protected elsewhere? As my first question, kind of following up there, which Douglas wants to answer. And my second question, you raised human rights law. Even if we consider the first strike law as this was valid under IHL, wouldn't it still be a violation of Article 6 of the ICCPR in the deprivation of the right to arbitrary deprivation of the right to life?
Okay, so can I take a first stab at a couple of things? So again, with my analytical doctrinal lawyer hat on, because I kind of agree with everything that's been said, but I'm just trying to keep us on some sort of rails so we can answer this a little like an exam problem. Strike against an individual, say a government leader by one state against another, on, as Alonso has said, if you say that a war can be commenced with the first shot, it might be legal under the law of armed conflict because you'd be targeting a legitimate target, say the leader of a country. So this is the thesis that the war starts with the first shot. This would be legal targeting under a war, therefore it's legal under that body of law. But it could still be, for example, an act of aggression, a violation of human rights, a violation of Article 51 of the UN Charter, and possibly a violation of Article 2.4 of the UN Charter. It's an illegal use of force. Now that's fine because it goes to the central paradox of how we attempt to regulate war, right? Which is that we say that it is bad and undesirable and we want all the constraints around it possible, but we want one body of law to apply once there is a war, regardless of who's in the right and who is in the wrong. That is, the aggressor is bound by the same rules as the victim, because very often states will have different views about who is the aggressor and the victim, and we need a stable body of rules that will minimize the damage done to civilians and combatants during an armed conflict. Now, we can deconstruct all of that with our critical lens or our sociological lens or whatever. That's the traditional justification. Now, so that's a targeted assassination of a single leader, single strike. I want to zoom all the way down to the other end of the spectrum with the Israeli raid on a hospital in the West Bank where 3 people were killed. Now, this goes to a number of legal issues, and again, everyone can pull this apart later from whatever angle. I just want to lay out the lex lata for listeners. In a non-international armed conflict, these persons would be not members of a regular military force, right? So the question is, they are targetable while they are direct participants in hostilities. So normally the problem this gives you in a situation like Afghanistan, which allegedly led to some of the frustration that underlay perhaps some of the Australian, UK and other war crimes, that you'd have this situation where people would be, herdsmen by day, insurgents by night, but you could only target them legally at the moment they picked up a gun and pointed it at you, right? But then even the Red Cross, the ICRC, acknowledges the concept of continuous combat function, right? So some people are a continuous part of the adversary's armed efforts, even if they are not carrying a gun or serving on the front lines at that moment. Now, the paradigmatic case would be a high command leader who would be targetable with lethal force in their sleep and even in their hospital bed if severely injured, so long as they were still capable of giving orders and directing operations, right? So as a matter of lex lata, I think that's correct. Emma and Alonso can come in against me if they've got a different view. The problem with that is then you get this devolution to incredibly fine-grained factual analysis, which has characterized a lot of the discussion around Israeli operations, saying, well, we can't possibly make even preliminary assessments until all the facts are in. And I can come up with 16 hypotheticals where what was done might have been legal. So I don't agree with that, because obviously international law is in part made by state practice, and state practice is judged by other states. So other states must be allowed in real time to say, this appears to be illegal. So it's a question of where the burden of proof is, right? So the party with greater control of facts and information should bear the onus of demonstrating that what they did was legal. But for an excellent piece on this, you can find an article by Mike Schmidt on the West Point Leader Institute Articles of War blog, where he goes through this incident. And he gets down to it, and I'm following him on his general principles, but then gets down to this bizarre contention that it would be legal to violate, or prima facie violate, the rules of perfidy for Israeli forces to dress as civilians, so long as their intent was to capture, not kill, right? Because then they weren't planning to use lethal force. And if there just happened to be an unexpected outbreak of lethal force at the end, well, then that would be acceptable. Now, I do not follow him to that point. The point I'm making is this: where we've got to is a point where the descent to the particular and the descent to the factual means everything starts falling away from you, right? And so in terms of Alonso's argument about how we use international law to justify things, it's a legitimate critique of a lot of the, frankly, borderline or actual apologism for Israel's conduct of recent hostilities, that there doesn't seem to be anything that's illegal, right? There's always either an appeal to some interpretation of the law or an appeal that we need to defer things until there are further facts. And so, I've written a piece that's easily Googled on the killing of the Australian national Zomi Frankum in the Israeli strikes on the World Kitchen food convoy, where I come to the conclusion, even on Israel's version of events, there is no conclusion other than this was a war crime, right? Because they targeted 3 vehicles, and the claim was, we thought mistakenly there was one insurgent on one vehicle. Now that could justify a kind of mistake of fact targeting decision against one vehicle. But the point was that what was clearly in operation was a decision, either at a tactical or a higher level, that there would be no survivors. So you targeted the first vehicle, maybe excusable by mistake of fact, then the second, then the third. At that point, you're plainly in war crimes territory, because you have decided to kill people who are prima facie civilian without any assessment of the evidence as to whether there was a legitimate target within them. The only way you can get to that conclusion is, well, the entire convoy is contaminated by this individual, and we get to wipe them all out regardless. So anyway, I've gone on too long, and it's something of a tangent, but I'm sure Emma has things to say.
Well, I think what I wanted to say actually flows on quite well from a point that you made about we're in this age of where we've got these really granular analyses of particular targeting operations or activities by militaries, or sort of these broader appeals to this is necessary. Something that I thought was really interesting about this particular, let's say the recent attack in Iran and Trump's decapitation of the Iranian government is that, and someone can stop me short if I'm wrong and I've missed something, but there wasn't really an appeal to Israel, and there wasn't really an appeal to sort of like this like legal argument that you might see from sort of like more of an Israeli in the sort of 2015 to 2020, 23 reign. And I think what's really interesting about that is lawyers really love to grab onto those sort of legal arguments and granularly comb through them with a fine tooth comb and say, that what's right about this argument is this, this, and this. But I haven't really seen that out of this particular attack. But nevertheless, in his tweet, he still sort of grabs onto this idea of precision warfare. And he says like precision bombing will still continue. And so to hark back to what Alonso was saying, I don't think that we should shy away from. In fact, I think as lawyers, it's really important for us to actively interrogate questions about the role that the law has played in the normalization of targeting violence, such as what we're witnessing now, witnessing carried out by the US and Israel and the UK for the last few decades. You know, the laws of war, jus in bello, are hailed as making war more humane and having a humane purpose. And I think there's definitely truth to that. And there's a lot of noble aims that certainly stem from IHL, though I note that, and Alonso is clearly aware of this, that Sam Moyne has outlined the problems with that approach as well. But what this dominant narrative conceals is that the law is sufficiently indeterminate, sufficiently flexible to give room for these quite violent interpretations. And we might disagree about these interpretations, and goodness me, haven't there been a lot of analysis in the last few weeks about lengthy and notable ones. I think there was an analysis of DPH by Mike Schmidt and Marko Milanovic that got quite a bit of analysis online. But I think it's required of us as international lawyers to sit and consider these kinds of analysis, that the law does have these consequences and can have these interpretations, whether they're intended or whether they're unintended.
But just on that, I mean, I think one of the problems we've got in this field is, at the risk of sounding a bit sociological, so Tamsin can slap me, a breakdown in kind of the relevant epistemic community around law of armed conflict. So again, for anyone listening to the podcast who isn't used to that particular fancy bit of terminology, which took me half an academic career to be that I actually understood. You know, an epistemic community is a body that shares a group of knowledge, right? And they share certain understandings of that knowledge. And I think one of the problems with law of armed conflict has become that we've got, and this has always been the tension, right, between the humanitarians and the operators, that humanitarian groups like the International Committee of the Red Cross have a protective function, so they're always going to take the narrowest and most restrictive interpretation of the law of armed conflict, whereas professional militaries are, hopefully, and in general, disciplined, ethical, professional bodies that want to be trained in the professional restraint of violence. I can see Tamsin having a certain reaction to that view, but in their ideal professional understanding of themselves, that's their approach. But nonetheless, there is always a drift towards the most permissive and expansive interpretations of the law, to the point where I think certain schools of interpretation of the law of armed conflict have got to the point where literally nothing is illegal. Right? And we've seen reporting out of the Gaza conflict, which said that literally no internal legal analysis had prevented any operation in Gaza. At which point you have to say, well, either the lawyers have become kind of the captives of the military and are no longer serving the law, they're just serving the state, or there's been a complete breakdown in what the function of the law is, right? But we definitely see in particularly American schools of law around conflict at the moment the idea that actually the approach we took in Afghanistan was too restrictive. Counterinsurgency warfare, the combination of precision weapons and the need to maintain the support of the civilian population, we can take both of those propositions with a heavy dose of salt, obviously, meant that we took overly narrow views of what the laws of war allow. And therefore, and I've had this put to me in all seriousness, therefore, actually, home front populations need to get used to the idea that a return to old school World War II large military operations is going to involve much greater civilian casualties and much greater civilian destruction, and all of that would be perfectly legal. And it's quite an extraordinary proposition to have put. So I think one of the problems we've got now is that the academic, the humanitarian, and the professional communities around this have fractured. And then even when we look at the approaches that would be taken by militaries, there's always been a lot of divergence between different militaries as to what would be acceptable, with typically the Israelis and the US taking the most forward-leaning approaches. I've spoken for too long. Alonso and Tamsin definitely want to come in.
Yeah, so I'm going to add a couple of things here and say that at a sociological level, we're probably also seeing a huge divide between the military hegemons and non-hegemonic militaries be in as an additional facet to that approach. I would say that yes, we're still getting a more permissive approach from even non-hegemonic military operators and lawyers, but it's probably not quite as permissive as the hegemons just because of power dynamics. I'd also say, and this is a shout out to my excellent colleague Shiri Krebs, she's done a lot of work actually arguing, and there's some nuance in the argument that she and I disagree about, but the general proposition's kind of bearing out pretty well that IHL has been manipulated to a point where it now exists to post hoc justify anything rather than act as a pre-targeting restraint. And there's some nuance. I said that we've had lots of debates around the nuance there, but mostly I think we're seeing her general proposition bear out in reality, particularly as it relates to, as you said, the US and Israel. And for context, Shiri is an Israeli citizen who is very anti what Israel's military is doing. So gives some context to her analysis there on this situation. So I'm going to throw to Alonso now because you had your hand up, but I wanted to kind of chime in with that little bit of detail.
Yeah, so I totally see what Douglas is saying about the how international humanitarian law slash law of armed conflicts is perceived, as in there are those of us who actually take care about the H in IHL, and then there are those who really don't want there to be an H in IHL, and so they say LOAC instead because it has A and C armed conflict. But and this is probably the result of having done a PhD on the history of international humanitarian law and having all of these like minoritarian views as a result. But I push back a little bit on the idea that there are two cultures within the academic community, the epistemic community of international humanitarian law. I think yes, there are people who interpret the law differently. Some more towards the H, some more towards the A and C. But I don't think it's because there's two overlapping epistemic communities within the broader circle of the people who study war. Because I put that discussion historically. And as Tamsin was saying, there is a mismatch between the hegemon, like in my research, I talk about like the bombers and the bomb, right? So editors hate that I do that. Like they always say, don't write this. It's not academic, but it's the only way to understand it in my view. There are parts of the world that are bombable and there are parts of the world that are not bombable. And so this is true. But when you put this discussion about the views of the bombed and the views of the bombers in historical perspective, you come to a law of armed conflicts that used to be came out of a very particular set of assumptions about what war is and how war is fought. I'm talking about Clausewitz, I'm talking about Lieber. War is hell. Sharp wars are brief, and war is, the pursuit of policy through other means. And so you had this very aggressive type of war as a result in like the time of the law of war in the 19th century, where like basically all you needed to do to have something be legal is it needs to be necessary to win the war. Because the most humane thing you can do in war is to end it quickly. So the most brutal war that you can fight, that's the humane war, because it'll end fast. And that, of course, that resonated, had its correlative with the people who were being bombed, suffering these like horrendously violent colonial small wars of conquest, without any ability to influence how these rules are assumed. And so in my PhD, I studied non-Western states and stakeholders saw these laws. And so Latin Americans in the 1800s thought that these rules, the way that they were being interpreted, were barbaric. Clausewitz was an insane way of reading the law. Going all the way to World War I, where we had several Latin American scholars saying that Europe had succumbed to a quote unquote cult of war. There's a very interesting historical source by a Nama leader in Southwest Africa called Hendrik Witbooi, and he wrote a diary of his encounter with German colonialists. Actually, Goebbels's father fighting a colonial war. And he writes how it's completely hypocritical and what's in the book does not correlate at all with practice, how it's horrible. And then you have Chinese and Korean people saying the same thing when the Japanese started embracing the laws of war. And so you have this like vast array of people that just had no ability to influence how the law worked because it was the law of the bombers. And then all of a sudden, a bunch of countries start becoming independent, decolonizing, the 1960s come about, and we start seeing a change in how international law starts to work. The H in international humanitarian law starts to become more important. The AC starts to become less important. Jessica White has written a really cool essay on how national liberation movements saw the idea of just war. And one of the things that she notes is, well, they were not Clausewitzian in their understanding of just war. They said war has limits. It's important for war to have limits. Not all of them did that, but several important ones did. You are the barbarians, colonizers. We are the ones that are defending these humane humanitarian ideas that you have been advancing throughout the decades, the century. And so instead of two cultures, I see a threshold, a historical threshold of an entrenched view of war as anything that's militarily necessary is legal, dwindling down, trying to disappear as the bombed have a stake in the regulation of war. And so I feel like the United States, Israel, and maybe stop counting. I don't know if there's another state that has a view like this, are sort of like the outliers, or those who have not gotten the memo yet that the H in IHL matters. And so I see this in a historical process. They just have way too many wars, but they are the bombers that still refuse to accept that decolonization happened and that the laws of war have changed and that they're not perfect, but they're supposed to be H. They're supposed to be humanitarian. In the 19th century, they were not supposed to be humanitarian. Sorry, now I've spoken too much.
Well, and I think we need to throw to Emma, but just on that point that these are the powers who have not accepted that decolonization has happened. I think we've actually reached a point in international law where a number of major powers have basically said, look, we're not international. You all need to learn to play by the rules. And as other states have learned to play by the rules and take a role in making them, the reaction has been, oh God, no, not like that. Anyway, Emma.
I should include Russia in the list of states that, violate.
I will also say that your comments around the barbarism of and hypocrisy of the West really resonated with me. Images of Justice Powell's dissent in the Tokyo trials. Emma, sorry.
Yeah, No, you're so fine. I have little to add. I thought that was a really good discussion and I really appreciate it. But I think my closing remarks on this would be that, particularly in regards to what Alonso has said, I think we can start to see why, when we couch things in these legal terms, whether it's a permissive regime or a restrictive regime, when we think about, bringing it back to the question of targeting and assassination and these precision practices in armed conflict taken up by these technologically advanced states that have the technology that enables them to do this, we start to see why we accept, or perhaps, like as Alonso said, maybe accept's not the right word, but tolerate this needing or the necessity of doing this in the name of wealthy capitalist liberal democracies. And you see this typical ideal political and economic system. Then we see why this behavior in armed conflict has transformed from something hidden, something celebrated, but also tolerated from some states to engage in this kind of behavior, where other states can't engage in that behavior, but also aren't protected from it. And so I think tracing that history of IHL is really important to understand why, at least in the discourse, if you put your doctrinal hat on, but at least in the discourse, some states can do things that other states just aren't allowed to.
Yeah, I think this has been a really fantastic discussion that I've really enjoyed everyone's inputs on, but we do have to wrap up for the sake of our listeners' time. So, in wrapping up, we usually ask a non-international law question about escape routes. What are people reading? What are they listening to? What are you doing to take your mind off international law and the horror show that it currently is? But for season 3 of Call to the Bar, I still haven't been informed of the official question. So I'm continuing with my comfort food question. So, what is your ultimate comfort food? Where can you get the best version of it? And where can listeners find a good recipe?
I'll start with that because I'm Peruvian and we're obsessed with food. So, um, the best thing you can give me to like bring me to a state of peace is ceviche, which is a Peruvian dish of like marinated fish in lemon with sweet potato, onions, corn, ají, and like all sorts of like
What's your
beautiful,
favorite
nice.
fish to use in ceviche?
So in Peru, you go to a restaurant and you order fish like you order wine. So they'll say like we have lenguado, which I don't know how to say in English, or we have corvina, or we have cojinova, or we have like whatever. And so it depends. But I do really like lenguado, which is like the fancy one. It's a flat fish. I don't know how to say it in English. One of the one that has eyes in the on one side of the body. So ceviche in Peru is almost like a social institution. When you want to talk to someone, you say, let's go for a cevichito," which was like a little ceviche, but like a cute ceviche. And you just go there and talk. It's implied that what you're gonna do is talk over food, which is something I used to do with my dad a lot when he was alive. We would go for ceviche once every month or 2 months. So to me, it has a personal aspect to it as well. Um, my sad part of all this is that there is no good ceviche in London. It's just there's one place called Tierra Peru which has good ceviche, but the best ceviche you can get in London is every year on July 28th, the Peruvian embassy organizes a Peruvian Independence Day celebrations in London. And so they hire this woman who just knows how to do ceviche and does ceviche like for the embassy once a year. And that is the best ceviche you can get in London. Find out where the July 28th celebrations are happening and go get your ceviche. And the best recipe for ceviche, I'm probably gonna be called a heretic by my fellow Peruvians, but it's the most widely available one. So there's a cooking book by Gaston Acurio, who's like our most famous chef, that is available anywhere in the world. So just get that book and make your ceviche that way.
Fantastic. Emma?
So as a proud Adelaidean, I have to give a shout out to a restaurant called Pawana. Pawana is an Afghan restaurant run by a family here in Adelaide. Their restaurant is amazing, but when I was an undergrad, they had a little pop-up shop close to the university where we'd go after lectures and get one of the curries. And my favorite curry, I'm sure I'm butchering this, but is bangan borani, which is deep fried eggplant and with this sort of tangy yogurt on top. And I just used to love it. And if you can get a reservation at Pawana, obviously that's the first place you need to go to get it because it is absolutely mind-blowingly delicious. But Pawana also have a cookbook and it is wonderful. And I've made the bangan biryani myself and it gets pretty close in taste. So if you're in Adelaide or if you're coming to Adelaide, Pawana is the place to be and the bangan biryani is their excellent dish. Highly recommend.
Awesome. Douglas?
Well, as a good Australian-British dual national and an regrettably uninformed meat eater, the Australian in me loves lamb, and the kind of adoptive Brit in me loves the British school of curry, which is obviously its own thing that doesn't one-to-one relate to subcontinent. But, you know, a lamb Rogan Josh is my ultimate kind of comfort food. But at the moment in Canberra, as the weather gets colder here, there's a lovely little restaurant in central Canberra called Little Steamer. It's a family hole-in-the-wall Chinese place, and they do an amazing steamed pork belly with fresh little buns. And I've got no idea how they do it, but it's the most amazing pork dish I've ever tasted. And I went there after seeing a movie recently with my wife, and it was just the most comforting, delicious autumnal meal if you're still, like me, an uninformed carnivore.
I feel like restaurants should like buy advertisement and call to the bar.
Look, not going to say no. But finally, Douglas, what are you wearing today for our listeners?
Yes. Okay, for those on the call, I've shed my outer layers, but today I was wearing a matching waistcoat and jacket set from some Yorkshire wool that was a pale green with a very broad window pane check with a vintage Tina Cosma tie. But with that, I was wearing some brown corduroy high-waisted Oxford bag trousers that I made myself in my recent sewing binge, which I was really happy with. And the first couple of times I wore them out and told friends that I'd made them, they said, really? I thought those would have been off the peg. So I think my sewing's kind of reached the level where things are beginning to no longer look home sewn.
Fantastic. And
I just say that the mythology of Douglas Guilfoyle has like fallen from me because he's not currently wearing a bow tie. I just can't.
This is my after 7, not at dinner wear, but yes.
But this should not exist, Douglas.
This isn't corduroy trousers, Alonso. You've got to take what you got.
Well, that is all that we have time for. Thank you so much for tuning in and listening. Bye-bye.